My name is Susan, and I will be your instructor as we talk about the Child Custody Information Sheet for Child Custody Mediation. This is Form FL-314, which you can download from your court's website. Let's take a look at this information. If custody and visitation are going to be issues in your divorce, you will need to seek orders regarding those issues. If you're fortunate enough to be able to reach an agreement with the other parent, you will be able to write that up as a stipulation and order, file it with the court, and the court will approve it and make it its temporary order. If, however, you're not able to reach an agreement with the other parent, you will need to file a request for order seeking orders regarding custody and visitation. To do that, you will also be required to attend mediation with Family Court Services before your court hearing date. This is to see if you can reach an agreement with the help of a professional. In some counties, if you cannot reach an agreement at mediation, the mediator is allowed to submit recommendations to the court for its consideration. Now, let's look at the information. If you're going to try to reach an agreement with the other parent, it's good to have some type of plan in your mind for parenting. There are many varieties, and in an agreement, you can reach any plan you both agree to. If you cannot reach an agreement, the court will consider various options. One of these is shared physical custody. This means that each of you will have the children with you approximately one half the time. If that's not possible, another plan is to have the children's primary residence with one of you, and the other parent will have frequent contact with the children through visitation. You should be thinking about what type of visitation and the amount of it that would be suitable. This includes the days and the times on those days for the other parent to have the child. You will also need to consider legal custody. This is the ability to make decisions for a child regarding that child's health, education, and welfare. Normally, if there are no reasons not to make an order for joint legal custody, that is what the court will do. This means that both parents must discuss and agree to those matters that are related to a child's health, education, and welfare, be that schooling, doctors, or treatment for medical and other injuries. If you cannot reach an agreement, you will attend mediation with Family Court Services. As I was saying, it is a good idea to have a plan in mind when you go to mediation. If you do not believe that shared physical custody is in the best interest of your child, go to mediation with some plan in mind for primary residency and for visitation for the other parent, including holidays, school vacations, and 3-day weekends. The mediator is a professional who will help you try to come to an agreement and will make recommendations and suggestions for you. If you are unable to reach an agreement at that time, as I said, in some counties the mediator will make written recommendations to the court. You will also receive a copy of the Family Court Service report. If you can reach an agreement, The mediator will write up that agreement, and you will receive a copy of that as well. You will take that, turn it into a stipulated order, which both parties will sign. You will take that to the court, file it, and the court will make it its order. I hope this instruction was helpful to you. Good luck with your issues related to child custody and visitation and mediation with family court services.